The European Small Claims Procedure. The European Small Claims Procedure is the third of the procedures in which the intermediate measures required for recognition and enforcement of judgments have been reduced, thus fulfilling the call of the European Council at Tampere. In that respect, it is similar to the European Enforcement Order and European Order for Payment Procedures. However, in other respects, it is very different from those two procedures. In the first place, the European Small Claims Procedure deals both with contested and uncontested cases, and so it contains provisions of a procedural nature, including for the holding of an oral hearing and the taking of evidence. It contains also a number of time limits, which, if observed, should enable the procedure even in defended cases to be concluded rather more speedily than under other procedures. The European Small Claims Procedure is basically a written procedure and is intended to be able to be used by claimants and defendants with the minimum of difficulty and without the need for legal representation, although that is not excluded. The European Small Claims Procedure, like the European Order for Payment Procedure, is only available for cross-border cases, and it is an alternative to national procedures of a similar nature. The successful party in a European Small Claims Procedure can expect to receive the costs from the other party, but only if these are proportional to the value of the claim. The aim of restricting the cost of the procedure is central to the aim that the European Small Claims Procedure should assist access to justice, in particular for individual consumers and for proprietors of small businesses who might not otherwise be willing or able to seek to pursue their claims in member states other than their own. The most important factor about the European Small Claims Procedure is the description of the claims which can be taken under the procedure. In the first place, these must not be above 2,000 euros in value, 5,000 euros as from the 14th of July 2017. This sum is to be calculated at the commencement of the claim and excludes any interest on the claim or expenses. If there is a counterclaim in a defended case, the counterclaim must not exceed the limit of 2,000 euros, 5,000 euros as from the 14th of July 2017 either, but the claim and the counterclaim are not aggregated to calculate the limit. As regards subject matter, claims of a civil and commercial nature can be taken under the European Small Claims Procedure with similar exceptions to those in the Brussels I regulation. There are some additional matters excluded, including employment claims, claims in relation to tenancies of immovable property, and delictual claims relating to infringement of the right of privacy and defamation. Enforcement of an order under the European Small Claims Procedure is similar to that in relation to the European Enforcement Order and European Order for Payment. A certificate is issued under the regulation by the court which granted the order, and the judgment is served on the parties. Once the certificate and judgment are available, no further procedure is required before enforcement can take place in another member state. As with the European Order for Payment, the forms for the European Small Claims Procedure are available online in the various EU languages. An electronic version can be completed online and, if permitted by the court with jurisdiction, can be transmitted online to that court. The European Small Claims Procedure came into force from the 1st of January 2009.